Regular meeting of Planning and Zoning Commission, City of Pearland, March 6th, 2017 at 6:30 p.m. Let the record show Troy Proddy is not in attendance. All other commissioners are present. Okay, moving on to consent agenda. Item 2, consideration possible action, approval of minutes and excused absence. Excused absence for Ginger McFadden from January 20th regular meeting. Consent agenda. Item B, consideration possible action, preliminary plat of Lake Park Phase 1, Section 3. Item C, consideration possible action, preliminary plat of Cypress Village, Section 3. Those are... Okay, the chair wishes to remove item B from the consent agenda. We have a... Does anybody wish to remove any other item? Do I hear a motion to approve items A and C on the consent agenda? Second. We have a motion and a second for items A and C on the consent agenda. All those in favor signify by raising your right hand. None opposed. Item passes 6-0. So we have item B, consideration possible action, preliminary plat of Lake Park Phase 1, Section 3. Do I hear a motion to approve?
Make a motion to approve preliminary plat of Lake Park Phase 1, Section 3.
Second. We have a motion and a second. We're in discussion. Can't see over the monitor. So I noticed this is a preliminary plat of Lake Park Phase 1, Section 3. It's my understanding that this has already been approved, preliminary plat and final plat. Is that correct, Vince?
Yes, sir, that is correct.
So is the applicant here? Make sure the mic's on. Sorry.
Whoops. I'm here to represent Windrose Land Services. Our client is Mr. Giles, and the reason why we issued a new plat is just because the previous developer was not cooperating. It's exactly the same plat, the same master plan. It's just basically our proposal is under the owner only. I know it's a little confusing.
That's all you know?
Would you mind identifying yourself for the purposes of our recording?
Absolutely. My name's Paula Lopez.
Thank you.
So this is unique in that somebody moved all the monitors up. That we normally don't get a preliminary plat unless something's changed. So what I'm hearing is the only thing that's changed is the name on the plat. The owner
No,
or the developer?
sounds to me like the developer got taken off and they went just under the owner's name.
Right.
Correct.
We're not working with the same developer.
It appears from the title block that the owner is still the same, but the owner agent is going to be the difference on the plat. However, this preliminary plat compared to the prior preliminary plat seems to be different. We can tell that by the number of notes on the plat alone. One has 17 notes, this one has 19 notes. Now, whether that comports with the final plat that was prior approved, we would have to have, staff might be better able to address that. I don't know what the line-by-line comparisons or differences are, but we do know that there are differences between the two preliminary plats. Without an explanation for those changes, I think that P&Z may want additional information to address that issue. Yeah. Another issue in regards to this plat that would actually require a difference is when the prior preliminary plat was provided, there was different ownership. One of the owners now, at least at the time of closing after the final plat was approved, was the city of Pearland. You may recall that the city of Pearland gained an ownership interest in this particular parcel of property. That was the type of security that was provided via deed of trust for the consideration of the final plat because the improvements had not been completed. I do not know at this time, and nor am I qualified to answer whether or not the deed of trust is still in existence or whether that has been paid off by some other means and additional security be provided. But just as the bank's information is on there because the bank has a lien interest on the property, if the deed of trust is still in existence, the city of Pearland also has an ownership interest in the property, and I believe its name should be over on the left-hand side of the preliminary plat as well. And city staff may have additional information on that. That's two of the things that I'm aware of that may cause some concern. And if you need the answers to those things, then I suggest you get the answers prior to approval and verify that there aren't any additional changes.
And who do you work for?
Windrose Land Services.
Surveyor?
Yes.
I'd like to add in reviewing this particular preliminary plat, I compared it with the final plat that had been approved by the P&Z, and all of the notes were matching what was on the final plat that was approved. All the developer had to do was get the final plat recorded because it had been approved by the P&Z, but that never happened. Instead, we ended up receiving initially a application for a minor plat, but because it was in a plan development, it had to go through the preliminary and final plat process.
So if there was a small change in it, like the developer or whoever in naming or how that was presented, why wouldn't that be a revision of the final plat?
I don't have an answer for that. I believe if there was something to be required, it would be a new final plat since the preliminary and final had already been approved. I don't understand why we're here with a new preliminary plat since we've already had final plat approval.
No?
I am more than happy to get you the answers to everything. Unfortunately, this is the first time I hear about this plan.
I would prefer that the developer be here. I'm opposed to this, and I'll vote no. Does anybody else have any questions?
I'm not sure if I have any questions or whether it's just so very confusing. If the final plat is approved and the final plat matches this revised or changed preliminary plat, is that correct? Do I understand that correctly?
Yes, the preliminary plat, as far as the notes and signature blocks and ownership signature blocks, are the exact same as what had been on the approved final plat.
But that would be a condition, or that would be a concern of the city's, if this deed of trust has us having an ownership interest in it, and it is the same, but it doesn't reflect the city's ownership interest the same way it does the bank's interest, that should be of concern to us if it is exactly the same in that respect.
We don't know that?
I do not know that. I don't know if anybody in our engineering department may know that, or if somebody in the planning department knows that. I think that we've been trying to find some answers and figure out what's going on. Unfortunately, I think we've had some communication with the surveying company, but we may not have gotten good answers from the owner on that.
And it seems the city's name should be added to that document.
That would be, if the deed of trust is still valid, and because the repairs have not been done, I would assume, because the construction has not been completed, I would assume that the deed of trust is still there in place as our form of security. The city's name should be on there reflecting its ownership interest because of that deed of trust. Now, sometime after final plat approval, it is possible that the deed of trust has been released and a different form of security has been provided. I would not have reviewed, from the legal department's perspective, I would not have reviewed that new document.
And normally, we would have a subdivision improvement agreement instead of this arrangement.
Who sets those up?
The subdivision improvement agreements. Usually they come through the planning department, and then they, after planning review, they get filtered to the legal and engineering departments for review.
So if, I'm sorry, Ms. Starr, I know that there's another monitor blocking the view over there, and I don't mean to be rude if I'm doing this.
That's okay.
I'm trying to make sure you can see me. But if a cash bond, for example, or if cash were provided, it may be that nobody had to review that. If it was in lieu of the deed of trust, that could be something that the finance department would have looked at. But because this is such a peculiar situation, I don't believe that we were able to verify that information, or nobody from the finance department is here in order to help you and give you an answer to that issue.
Would not someone had to have done a release of lien?
I would have think so.
And I would have thought that would have come to the legal department?
I would have thought so as well. I can tell you that I have not reviewed a release of lien for the deed of trust. But it is possible that my boss reviewed it for some reason instead of me, and unfortunately, he's out of the office today and this week, so I wasn't able to verify that with him. When he and I had spoken about this last week, or 2 weeks ago when we saw it on the Development and Review Committee, we thought we needed more answers, and we were trying to get those answers prior to today. Unfortunately, we don't have those answers to provide you.
Okay.
I guess to further my comments, we've already approved a preliminary plat, we've already approved a final plat. As far as I'm concerned, we're done. If something else is there needs to be a good explanation why this is back, to have the agent, someone's agent come here and represent them for something that seems really odd to us. They need to be here. If not, I say we just deny it. That's my opinion.
And I don't want to misspeak on behalf of the owner, but if we had a final plat that was approved and the city signed it, pursuant to the city's standard procedures, after we sign, the city gets all of its signatures, we give the document back to the person who requested it, and that person is responsible for recording it. If something happened to the final plat that prevents them from submitting it, there was a flood, there was a hurricane, there was a tornado, or whatever might have happened that stops them from doing that, I would imagine that we would understand that. I don't know if we have copies of that original one and we could just release it again. It sounds like there's been a business dispute between the owners, if I'm hearing correctly. So the person who is holding it refuses to release it, but that's the person who came to you and talked to you or presented things to council, and now we have somebody new, and I don't know if we know that person. I don't know if we have that relationship with them, and I don't know why we can't just or in their business dispute, why they can't just resolve that to have it done. But if we just need to put new signatures on the prior approved final plat, that's something that's possible, and we don't need to take any additional action other than to get those signatures, and re-sign it. But
it makes no difference as far as if it's a different developer or not one. That makes no difference to us as far as that document.
I don't think it would be any different from our city manager changing or city council changing or chair of P&Z changing. The plat is in the name of the owner, which is, I think it's Cullen Stone Limited or Cullen Stone LO. I don't have it in front of me. I'm sorry. I would have to double check. Pearland Cullen Stone Properties LLC. That is reflected on both final plats and both preliminary plats. It's just underneath Pearland Cullen Properties LLC. It says James Johnson or it's Mr. Giles, I believe is who it is now, Mr. Giles. So, that's who's acting on behalf of the owner, but the owner is still Pearland Cullen Properties LLC.
And I would also like to state for the public record that I had not received any Mylars of a final plat to get signatures. It's our standard operating procedure that once the Planning and Zoning Commission approves a final plat, the surveyor or their engineering firm will generate a set of Mylars that will obtain the signature from the owners, and then also city engineering, the legal department, and then also the chair of the Planning and Zoning Commission signs off on the plats that are approved by the Planning and Zoning Commission. But I have not received Mylars for the final plat that had previously been approved by the Planning and Zoning Commission.
And I guess the implication of action tonight would actually change the submittal required dates for different things. As you recall, this is a planned development, and certain things have to happen within 6 months and 2 years of each approval. So if you were to approve something new, you reset the clock on those things, and especially with the planned development, there's an auto expiration date in those for a reason. It may no longer be the planned development that you want it to be. Now, there are some things already going on that property. I don't want to say that, we're going to completely change those things, but there is an implication that could happen by changing the submittal date. And this particular lot is, as I understand it, the lot that has the public infrastructure with the trailhead and the parking lot. And I'm sure that, that was one of the things that was negotiated as part of the development agreement and part of the planned development, because we wanted to make sure we had those things. So they still need to be in place. The question is, when do they need to be in place? And do we want to change the date for that? And then is this a refiled preliminary plat the appropriate mechanism for what they're trying to do today? Especially without answers to the questions, I would suggest to you that that is not the appropriate action. But once they give those answers, if it makes sense then, maybe it would still seem as though the final plat would be the appropriate next step instead of the preliminary plat, but...
Am I wrong in thinking that they could take care of all of this with staff? They wouldn't need us to do anything? I mean, if we were to approve this, all it does is set it, it starts it all over again.
No, if I understand correctly, if we approve this, it starts over again with any subtle changes that might be in this that we're not aware of.
Right.
Yes.
They could just work with staff to refresh the signatures on the current documentation and go forward from there with the original.
We're thinking that that would be the more appropriate thing, but we would have to, we still haven't heard directly from the owner, only through the surveying company, to help understand what these changes are, or we don't understand what the obstacle is. When you break up, so to speak, when you get a divorce, even if it is a business divorce, there's a judge who says, you get this, you get that, and by operation of law, you have the authority to sign these things. We haven't seen any paperwork like that suggests that that's what it is. We've just heard through the survey company who said that there's a change in ownership. The prior person holding it refuses to give it. I don't understand those things. As Vince had said, after the final plat was approved, he never got Mylars to circulate for signatures. So if it's just somebody's name has changed but the company is the same, I believe that we have the authority on the staff level to make that change, the same way we would if the city manager or the chair of the P&Z had changed, without additional action from this body being taken.
And that has happened in the past with plats, not only just ones approved by the Planning and Zoning Commission, but plats that are approved administratively. Sometimes we've had changes of staff, and the Mylar would be generated prior to us knowing who the name of the new individual at the city would sign off on the plat.
But if something like that were to happen, I believe the approval date on that final plat would still reflect when the action was taken, not new action being taken, which is what would happen if you approved this preliminary plat and then subsequently the final plat that would come after that. Plenty of information. I still feel as though it's not the information you need to make a decision, though.
Clear as mud. Anybody have anything else? Care to vote? All those in favor, signify by raising your right hand. All those opposed? Motion denied, 0-6. Moving on to new business. We have no new business. And item 4, Commissioners' activity reports. Anyone?
Basically, I had been asked to remind the commission of the, under the discussion items of the ULI Houston on April 13th. If anybody's interested in going, Judy Brown in the Community Development Department needs to know as soon as possible, because I've been informed that those slots are limited.
Okay, thank you. So I guess if anybody knows they can go, let staff know. Next P and Z meeting is March 20th. Looks like it's a JPH.
And we just remind the commission that we flipped dates because today was Brazoria County Day. A lot of our elected officials were going to be in Brazoria County Day up at the state capitol. So we swapped our JPH dates, and if you're not going to be there and we have, because of that change, and we're not going to have a quorum, please let us know as soon as possible, because I think we had a few issues that are on that agenda that we're hoping to resolve.
Anybody else? Anything else? Nope. We'll adjourn at 7:06.